How does DRL Section 236(b) equitable distribution affect what we can negotiate in mediation? If you and your spouse are considering mediation, you may be worried that New York's equitable distribution rules could restrict what you can agree on. Domestic Relations Law Section 236(b) actually expands your options rather than limiting them. This statute sets the framework that courts use to divide marital property and calculate spousal maintenance. In mediation, you can rely on these rules as a baseline and then craft agreements that go beyond what a judge might order. DRL Section 236(b) treats marriage as an economic partnership and defines the difference between marital and separate property. Marital property generally includes everything acquired by either spouse during the marriage, such as homes, retirement contributions, investments, and business interests. Separate property includes assets owned before the marriage, gifts, inheritances, personal injury compensation, and property designated as separate in a valid agreement. Understanding this distinction is essential because only marital property is subject to equitable distribution, while separate property remains with the owning spouse. The statute lists 16 factors that courts consider when dividing marital assets. These factors include each spouse's income and property, the duration of the marriage, custodial housing needs, and the loss of pension or health insurance. They also take into account non-financial contributions, the liquidity of assets, future financial circumstances, tax consequences, and any wasteful dissipation of assets. In mediation, these factors serve as guideposts rather than strict rules, and you can agree to any division that seems fair to both parties. For example, you could negotiate a 60/40 split of assets or agree that one spouse keeps the Manhattan apartment in exchange for a larger share of retirement accounts. You can address issues that courts rarely consider, such as private school tuition, frequent flyer miles, or emotional attachments to the family home. DRL Section 236(b)(3) explicitly authorizes spouses to enter agreements about dividing property and states that courts will generally enforce these agreements if they are fair and voluntary. When it comes to spousal maintenance, the statute provides formulas for calculating both temporary and post-divorce support and sets an income cap for applying these guidelines. In mediation, these formulas act as a starting point, and couples can agree to different amounts or structures such as lump sum payments or shorter durations than the advisory schedule suggests. Retirement accounts and pensions earned during the marriage are considered marital property and often require a qualified domestic relations order to divide. In mediation, you can decide how to handle these accounts, through offsets, lump sum buyouts, or neutral financial valuations, avoiding contentious court battles. The statute does not treat enhanced earning capacity from a professional license or degree as marital property, but a judge may consider a spouse's contributions when dividing other assets. If one spouse owns a business, mediation lets you hire a single neutral appraiser and negotiate buyout terms that keep the business intact. The marital residence often has emotional significance, and courts consider whether a custodial parent needs to occupy the home, but mediation allows flexible arrangements like buyouts, deferred sales, or agreements to stay until children finish school. Before beginning mediation, gather financial records, identify which assets are marital or separate, review the equitable distribution factors, and understand maintenance formulas. Each spouse should retain their own lawyer for advice, because mediators are neutral and cannot represent either party. A knowledgeable attorney will review proposed terms, identify potential issues, and ensure that the final agreement protects your interests. Working with a Manhattan divorce mediation lawyer like Ryan Besinque can help you navigate DRL Section 236(b) and craft creative solutions that fit your unique circumstances. His law firm assists couples throughout New York City with property division, maintenance, and other financial issues, guiding them from financial disclosure to final agreements. If you have questions about how equitable distribution rules apply in mediation, consult a divorce attorney who understands the law and the process. The law office of Ryan Besinque is ready to help you and your spouse reach fair and practical agreements. Contact the law office of Ryan Besinque at 115 West 25th Street 4th floor, New York, New York, 10001, United States, or call 929-251-4477 to schedule a consultation.